Today, we're diving deep into the US Constitution, specifically Article 2, the heart of presidential power. We'll unpack what it says, why federal district judges have little say over it, and how an old law called the Alien Enemies Act fits in. This is a big topic, so stick with me. It's detailed, it's fascinating, and it's all about how our government works. If you like this kind of deep dive, hit that like button and subscribe for more. Let's get started. So, what's Article 2 all about? It's the part of the Constitution that creates the executive branch and hands the president the keys to the kingdom, or at least the executive power. It's shorter than Article 1, which sets up Congress, but don't let that fool you. It's packed with authority. Here's the breakdown. Section 1 says, the executive power shall be vested in a President of the United States. That's a big deal. It's not just a list of tasks, it's a broad grant of power. Think of it like the framers saying, you're the boss of getting stuff done. It also sets the 4-year term and the Electoral College, stuff we're all familiar with. Section 2 gets specific. The president is the commander-in-chief of the military. He can pardon federal crimes, except in impeachment cases. And with Senate approval, he makes treaties and picks judges or ambassadors. Oh, and he can demand reports from his team, keeping the executive branch under his thumb. Section 3 adds the take care clause. He's got to make sure laws are faithfully executed. That's a duty, but it also gives him wiggle room to act. He also gives the State of the Union and can call Congress into session if things hit the fan. Section 4, that's impeachment, the only constitutional break on this ride. The framers, like Alexander Hamilton in Federalist No. 70, wanted a strong, single executive. Why? The Articles of Confederation had a weak executive, and it was a mess. They needed someone who could act fast, especially in war or foreign affairs. Article 2 delivers that energy, and it's why the president has so much sway today. Now let's talk courts, specifically federal district judges, the trial-level folks under Article 3. Can they tell the president what to do with his Article 2 powers? Spoiler, not really. Here's why. Separation of powers. The Constitution splits government into 3 branches: legislative, executive, and judicial. Article 2 stuff like military command or foreign policy. That's core executive turf. Courts, especially lower ones, don't have the chops to micromanage that. Back in 1803, Marbury v. Madison gave courts the power to check laws, but not to run the White House. Political questions. Some decisions, like sending troops or negotiating with another country, are political questions. The Supreme Court, in Baker v. Carr, 1962, said if the Constitution hands a job to the president, courts back off. District judges, sitting at the bottom of the judicial ladder, aren't built to overrule that. Jurisdiction limits. These judges get their power from Congress and can only hear certain cases. Telling the president how to do his job, that's a stretch. In 1867, Mississippi v. Johnson, the Supreme Court wouldn't even let a state stop President Andrew Johnson from acting. Separation of powers again. Precedent. Look at Curtis Wright in 1936. Courts gave FDR a blank check in foreign affairs. Are district judges meddling there? It's like a referee trying to coach the team. The big case to know is Youngstown Sheet and Tube from 1952. Truman seized steel mills during the Korean War, and the Supreme Court said no because Congress hadn't signed off. But Justice Jackson's opinion said that when the president got congressional backing or clear Article 2 power, his authority was at its peak. District judges rarely mess with that. Okay, let's zoom in on the Alien Enemies Act. 50 U.S.C. Parashah 21 to 24. This law's been around since 1798, born during tensions with France. It's narrow but powerful. Here's what it does. If there's a declared war or an invasion or predatory incursion by a foreign nation, the president can detain, restrain, or deport anyone over 14 who's a native or citizen of that enemy country, if he thinks they're a threat. He sets the rules and announces it publicly. It was used in World War I and II. Think German or Japanese nationals rounded up. Harsh? Yes. Legal? Courts said so. Why can't district judges stop this? Congress said so. The Act's a clear law backing the president's Article 2 war powers. In Youngstown terms, that's max power territory. National security. Wartime enemy aliens? That's the executive's wheelhouse. Even in District judges aren't war strategists. Executive discretion, deciding who's a threat or how to handle them, that's the president's call. Courts might tweak individual cases, like Ludecker v. Watkins in 1948, but not the big picture. History. FDR used it in WU too, and district courts didn't blink. Higher courts reviewed specifics, but the policy stood. Today, it's rare, no declared wars since 1945, but it's still law, and it's still the president's domain. Now, to be fair, there's pushback. Courts can check unconstitutional acts. Marbury again. If a president went wild with the Alien Enemies Act, like targeting non-enemies with no war, a district judge might step in for due process. Post 9/11, cases like Hamdi v. Rumsfeld showed courts aren't hands-off on detention, but broadly blocking Article 2 powers? That's a tall order for a district court. So here's the takeaway. Article 2 makes the president a powerhouse, especially in crises. The Alien Enemies Act doubles down on that in wartime. Federal district judges? They're not powerless, but they're not in the driver's seat either. The framers built this system for speed, unity, and strength in the executive. Love it or hate it, that's the Constitution at work. What do you think? Should courts have more say, or is this balance right? Drop your thoughts below, and if you enjoyed this, smash that like button and subscribe. See you in the next one.